Gary DeWall here, and this is Bridging the Week for October 27th to 31st, and today is November 3rd, 2014. Good morning. Three regulators, the Commodity Futures Trading Commission, the Securities and Exchange Commission, and the Korea Financial Services Commission, took practical approaches to operational hurdles posed by their previously adopted rules. Has the pendulum of knee-jerk regulation in response to the financial crisis beginning in 2007 finally started to inch back towards a more sensible position? Meanwhile, the CFTC also approved one university to begin taking orders for binary options to help predict certain U.S. election outcomes, but solely for research purposes. There was a lot going on last week, so let's get started. The Division of Market Oversight of the Commodity Futures Trading Commission authorized the Victoria University of Wellington, New Zealand, to operate a marketplace for the trading of certain winner-take-all event contracts and to offer such contracts to U.S. persons without registration as a trading facility under relevant law and CFTC rules. The contracts, often known as binary options, include contracts to predict events related to the selection of the U.S. President and Vice President, as well as which party will control Congress, and decisions of the Federal Open Market Committee regarding the federal funds target rate. In connection with this proposed marketplace, CFTC staff will not require Victoria University to register as a designated contract market, swap execution facility, or foreign board of trade. Staff condone limited advertising that prominently discloses that the marketplace is, quote, unregulated, experimental, and being operated for academic purposes, end of quote. Let the research begin. Goldman Sachs Execution and Clearing requested and obtained relief from the Securities and Exchange Commission related to certain of its closeout obligations under Regulation Show. Reg Show requires a firm to close out short sales where an account has failed to deliver the required security by certain deadlines. Closeout is achieved by the firm borrowing or purchasing the like kind and quantity of the relevant security. However, a firm will not be deemed to have satisfied its Reg Show requirements if, on the same day of its mandatory closeout activity, it reestablishes a short position without being able to demonstrate a legitimate economic purpose. By end of a required closeout deadline day, a firm, on an aggregate net basis, including all its cleared client activity, must be a net purchaser of the number of relevant shares at least equal to its closeout obligations. Goldman Sachs claimed it had difficulty meeting its requirement for various operational reasons. To address SEC staff's concerns regarding subsequent sales and its operational challenges, Goldman Sachs proposed a quote-unquote new approach that would authorize it to close out impermissibly reestablished positions on the day following ordinary closeout deadlines. However, in return, among other steps, the firm would endeavor to better identify and hold accountable relevant clients to their own closeout obligations and escalate problematic customers and transactions to the firm's compliance department for consideration of other actions. Coincidentally, the Financial Industry Regulatory Authority fined two Merrill Lynch companies $6 million in aggregate for not complying with certain requirements related to Regulation Show, as well as supervisory failures. The two Merrill Lynch entities are Merrill Lynch Professional Clearing Corporation and Merrill Lynch Pierce, Fenner & Smith Incorporated. According to FINRA, from September 2008 through July 2012, Merrill Lynch Pro did not close out certain failed-to-deliver positions as required and did not have adequate systems and procedures to address Reg Show's closeout requirements. In addition, from September 2008 through March 2011, FINRA claimed that Merrill Lynch's supervisory systems and procedures were also inadequate and permitted the firm to allocate failed-to-deliver positions to customers based on their short position without regard to which customers actually caused the firm's failed-to-deliver position. FINRA also cited both Merrill Lynch companies for anti-money laundering violations and Merrill Lynch Pro for books and records violations and for not adequately monitoring the order flows of certain of its clients who were permitted to trade directly through certain market centers. Both Merrill Lynch companies agreed to the settlement without admitting or denying any of FINRA's filings. CME Group brought and settled over 20 disciplinary actions for payment of fines of between $400 and $5,000 US for violations of its requirement that all persons accessing Globex for a member firm use a unique identifier known as a Tag 50 user ID. In the cases, CME Group claimed that the clearing member firm failed to quote-unquote properly register Tag 50 user IDs and permitted orders to be entered on Globex quote-unquote using incorrect Tag 50 user IDs. Some firms received multiple sanctions. Beginning in 2018, banks will be required to have more liquid assets to cover their short-term exposures to other banks and financial institutions, derivatives, and assets used as initial margin for derivative contracts. The requirement imposed by the Bank for International Settlement, termed the Net Stable Funding Ratio, will discourage banks from using short-term funding to cover long-term obligations. Essentially, banks will be required at all times to have cash or assets readily convertible to cash to at least fund their anticipated obligations for the next year time frame under ordinary operational conditions. The European Commission has recognized the regulatory regimes of 4 jurisdictions as equivalent to the European Commission in connection with their oversight of clearinghouses. These regimes are Australia, Hong Kong, Japan, and Singapore. As a result, clearinghouses in these jurisdictions may provide clearing services to European Union-based clearing members, may be used by EU counterparties to satisfy mandatory clearing obligations, and will obtain so-called qualifying CCP status. This status permits European banks utilizing such clearinghouses to avoid certain penalty capital charges beginning December 15th. The EC had not yet officially recognized as equivalent oversight of clearinghouses by the CFTC or the SEC. However, previously, CFTC Chairman Timothy Massad announced that European regulators had agreed to postpone the imposition of higher capital charges on European banks for dealing with U.S. clearinghouses that otherwise was scheduled to occur on December 15th. And finally, the Korea Financial Services Commission has published a plan to jointly ease certain burden on companies that are within a domestic financial holding company structure. Among other things, FSC proposes to ease restrictions on granting credit to certain overseas affiliates and expand the scope of certain credit evaluation outsourcing permitted among affiliated companies. Well, that's it for this week's Bridging the Week. As always, there is more information in each article and more articles on the article version of Bridging the Week on this website. Check it out. Until next week, this is Gary DeWall. Have a great week, and don't forget to vote tomorrow. Ciao!